Ravenelli. I'm the association's attorney, and we're going to talk today about a topic that I believe is one of the most complicated parts of the purchase agreement, and that is the contingency for the sale of either the buyer's property or a finding by the seller of replacement property. So first question, what is a contingency? Again, there's about 9 contingencies that could exist in a purchase agreement, a standard RPA purchase agreement. A contingency is actually a condition precedent to the party's obligation to perform. So if I have a contingency to sell my house before I have an obligation to close escrow on the house that I'm buying, and I cannot meet that contingency or any of the other contingencies, I will not have defaulted on the transaction because my obligation to perform that particular requirement of the contract has not been met, and I am therefore going to be entitled to get my deposit back. If the seller doesn't find suitable replacement property, as I'll talk about later, the seller would also have a right to cancel. I believe that the contingency for sale of the buyer's prior property is the most complicated, because think what you're doing here. You're trying to figure out from the standpoint of using a form what might happen with all of the variables. Will that property go into escrow? Is it even listed? Will the sale close? Will there be a cancellation? What if the seller gets a suitable backup offer? All of those things and more have to be taken into account because of the legal implications. Then, of course, you've got the logistics of everything. Will things close concurrently? If the seller is the buyer somewhere else and that buyer is a seller somewhere else, are there going to be issues relating to the concurrent closing? Will people have to stay in motels and store their furniture for a little while? Will there be leaseback arrangements? All of those things are very, very complicated, and in this current market may not necessarily lead to a seller accepting an offer. As the market starts to shift and buyers get put into a different situation, which may or may not happen in the years to come, we may look at things differently. So what we're talking about today, essentially, is I've heard it called a chain transaction or a concurrent transaction or a contingency sale transaction. Essentially what's happening is if one of the transactions fails in any of the chains, then the whole thing may collapse. So why would a buyer want to do this? Well, number one, of course, is it may give them time to sell a house that they must sell. And they might need to sell that house because, number one, they simply wouldn't qualify for both loans being in existence at the same time. They may need the proceeds of the sale of one property in order to complete their sale of the property that you're handling. It prevents owning two mortgages at the same time. It may affect or delay the buyer having to spend money on inspections for property that they're purchasing or other cost of escrow. And it also preserves, to the extent that people act in good faith and that the contingencies are carried out, the buyer from losing their deposit. I want to emphasize one little side point here. If the money that's being generated from the sale of the buyer's property is sufficient to pay cash for the house, it still is not a technical cash transaction because the cash does not exist as of the day that the offer is accepted. From a seller's standpoint, a home sale is risky. There's no question about it because, again, there are so many variables that could take place. And even if the contract allows the seller to continue to market the property and accept offers, it may limit your market because other buyers may not be interested in a contract or a property that is under contract, and it might make it less attractive. It might also indicate that the property is going to be on the market longer, which may not necessarily be a good thing. And so a lot of this really depends on the property's, on the party's bargaining position. It's a strong suggestion. I've talked to a number of brokers. Again, as many of you know, I'm just a lawyer. I'm not a realtor, but I've been talking to some brokers who deal in this all the time. And certainly you want to do your preliminary research if you're representing the seller as far as that buyer's property. Asked to see contracts, asked to see escrow instructions, asked to see some things so that you can verify for that seller whatever you need to verify in terms of on a go-forward basis. Of course, there are forms for all of this. The RPA has a specific section, paragraph 5. Again, if their contingency is not going to exist, you move on to section, I'm sorry, I said section 5, it's section 4. You would move on to section 5, and if in fact this contingency will exist, you will check off the box, and then you will fill out what is an addendum. Whenever you see the word addendum, it means it's part of the contract. An addendum is Latin, and it means it's part of the contract. The contingency form is the COP, and I'm going to go over that with you in a second. Again, the purpose of the form is that if the contingencies cannot be met for any reason, it gives the buyer an out so that they can cancel the contract, and assuming they have acted in good faith, it authorizes the return of their deposit. It also protects the seller because if the contingency is not met, the seller, under the circumstances of whatever has been agreed to, can provide a notice to perform and can then cancel the contract themselves. So it does give some benefit to both parties. Let's talk then about the specifics. And I'm just going to go through the form, which is a one-page form. It was amended back in December of 2017. And that the current form, again, is the COP revised 1217. Paragraph 1, it defaults that the contingency lasts for the entire escrow period that the buyer is purchasing and provides very strong buyer protection. However, if the property is already in escrow, the contingency could end, depending upon the boxes that you check off, when the buyer's property is supposed to close. And again, timing becomes critically important. Paragraphs 2 and 3 identify if the property is or is not already in escrow. If it's not in escrow, then the seller is told that the property is listed with whom, what the MLS number is, and so particularly with the size of the MLS that Pacific West has, you can go into that MLS and get some good information, because more than likely the property is listed either in CRMLS or in a reciprocal association. Again, if the property is in escrow, the seller can be told when that escrow is scheduled to close, and the maximum amount of time that property is going to be in escrow. And of course, proof can be requested if you check off the correct box to establish that the property actually is in escrow with whom, and the contract does require that certain evidence be provided to the seller within a specified time in order to confirm the representations that the buyer is making. Paragraph 4 is a requirement that the buyer needs to tell the seller if there is an attempt to cancel the buyer's prior transaction, so that the seller knows what's happening with that prior transaction along the way. And of course, paragraph 5 is the seller's right to cancel, which there are essentially 4 choices there. If the property of the buyer does not close on time, the seller can give a notice to perform in whatever method the parties have given. And if it's a legitimate notice to perform, 2 days after that, unless that day falls on a Saturday, Sunday, or holiday, the seller can cancel the transaction. If the buyer doesn't provide evidence that the buyer's property is in escrow, again, the seller can provide a notice to perform and then cancel. If either the buyer or the buyer's buyer attempts to cancel that transaction, the seller is to be notified and under circumstances can cancel. And of course, if the seller gets a backup offer and the buyer won't remove contingencies within the context of the agreement. Gives the buyer a chance to back out under paragraph 6. Again, the buyer can back out if his deal doesn't go forward, and the buyer has two opportunities. One, if the transaction does not get into escrow a certain time or close, or if that buyer's buyer cancels that transaction. If the parties want to negotiate something further, they can, and it may give the buyer an opportunity to find another buyer if the seller's willing to go along with that scenario. Under paragraph 7, the buyer's purchase of seller's property will proceed as any other purchase, but the buyer has a certain number of days to then make the deposit and move forward with inspections, and then the contract becomes your standard contract where all the other contingencies will come into play and all of the time elements will be impacted. And again, if the buyer fails to treat the transaction appropriately, the seller has other bites of the apple. Paragraph 8 says that even after accepting the buyer's offer, the seller can continue to market the property. Make sure you put the correct status in the MLS within 2 business days. If a backup offer is acceptable, the buyer can stay in the transaction by simply removing the contingency upon the notices that are required. The buyer does not ever have to match the backup offer, but does need to make a determination to cancel or remove contingencies within a certain period of time. Typical that I've seen is 72 hours. Again, there may be other contingencies that are being tracked. It depends on what the parties agreed to. Of course, proof of funds still has to be proven, and the seller can continue to market the property. Take a hard look at paragraph 8b. The buyer can delay the seller's right to force the buyer to remove the contingency, again under certain circumstances. So, as I said before, it is my view that you need to be particularly careful about this situation, because if you elect this particular contingency, you're basically stepping into a lot of unknowns unless the buyer's property is every bit as close as it can possibly be to closing, and you simply need a little bit of time to get that deal closed. But if that property hasn't even been listed, if the property hasn't been put into escrow, you have all sorts of issues. Couple that with the fact that the buyer is now a seller, and that seller is going to sell to a buyer who may have their own contingencies, and you can see how the logistics of any given transaction can be very complicated. Not referenced in the contract, but available to members, is a situation, and to my knowledge, one of the few, if not only, seller contingency, and it's the seller's purchase of replacement property, the SPRP, which was also revised in December of 2017. This is a situation where, for whatever reason, the seller needs to find a replacement property. I'm moving from one area to an area with very limited inventory, or maybe I'm moving from an area where properties are substantially more expensive than the area I'm moving from. And I want to make sure that I am able to find a replacement property, and I want to make that a contingency as the seller of my obligation to close. And you would use that form. It is much more simply stated. And there are basically a couple of scenarios. First of all, you have to put the contingency in the MLS. There are MLS rules regarding that. You can go to the MLS rules and take a look at that. Secondly, you have one of 2 elections you can make. One election is that you go into escrow and you're reasonably comfortable that you'll close. The other is you actually have to close escrow number 1 before you have an obligation to sell to that buyer. And of course, good faith is always an issue. Be careful about this. I saw a case not too long ago where it looked to me that perhaps it was the seller's intent to create a contingency, but they didn't use that. They simply indicated that the sale had to close concurrently. The trouble was, if it didn't close concurrently, then what happens to the transaction. Is the seller going to lease back for a short while? If so, under what terms and conditions? So be very, very careful about both of these contingencies, again, because you're trying to figure out what's going to happen in the future. And although that's true of a lot of situations, lender approval and all those kinds of things, this is one where there's a lot of variables and you need to be very careful. So that pretty much covers a very simplified version of a very complicated transaction. I invite you to let me know what topics, if any, you're interested in. We do one of these rants every month. What we do is we look and see what kinds of calls have come in from the members and what seems to be an issue at that particular point in time. And then we create a rant to try and cover the issues that are important to you. In the future, we'll be talking about what's going on at CAR, which their business meetings are coming up. We'll probably talk about forms that'll come out in December and whatever other topics you find interesting, confusing, or that you simply are having trouble with. And the more people that let us know that, the more likely it is your topic will get covered. So until next month, I'm John Giardinelli, representative Association Counsel for the Pacific West Association. I thank you for your time and look forward to hearing from you in the future. Thank you.